X. The judge didn't laugh out loud. It was worse than that. It was the kind of laugh that stays behind closed lips. A slow exhale through the nose, a tilt of the head, a look exchanged with the bailiff standing near the door. The kind of laugh that says, "We don't need to say anything. We already know how this ends." X. Adaeze Obi stood at the front of that courtroom in a blazer she'd borrowed from her aunt, holding a manila folder thick enough to be mistaken for a textbook, and she didn't move. She didn't blink. She just looked at the judge and waited. X. She was 24 years old. She had no law degree. She had no legal training, no bar number, no letters after her name that meant anything inside a courtroom. What she had was 4 years in the Canadian Armed Forces, 2 deployments, a photographic memory, and a grandmother who had just lost her home to a man who had never once in his life been told no. X. Her grandmother's name was Vivienne Obi. Everyone in the neighborhood called her Miss Viv. X. Miss Viv had lived in the same house on Carlton Avenue in Windsor, Ontario for 41 years. She had raised 4 children in that house. She had buried 1 husband in that city. She had painted the front door herself, a deep burgundy, and every spring she planted marigolds along the front walk because marigolds, she said, kept the bad things away. X. They didn't keep Gerald Prentice away. X. Gerald Prentice was 63 years old, semi-retired, and had spent the better part of the last decade buying up properties in working-class Windsor neighborhoods, flipping them, and moving on. He wore boat shoes indoors. He drove a white Range Rover. He had a real estate lawyer on retainer and a financial advisor who sent quarterly reports. And he had never, not once, met a situation he couldn't manage with the right paperwork. X. The paperwork was the problem. X. 3 months before Adaeze walked into that courtroom, Miss Viv had received a notice from the city of Windsor indicating that her home, the house on Carlton Avenue, the one with the burgundy door and the marigolds, had been transferred to a numbered holding company. The transfer had occurred 14 months prior. Miss Viv had not signed anything. Miss Viv had not agreed to anything. Miss Viv had been in Scarborough visiting her sister when it happened. X. But there was a signature on the document. It looked enough like hers that nobody who didn't know her would question it. X. And the city, for its part, wasn't asking questions. The city was processing paperwork. That's what cities do. X. Adaeze found out on a Tuesday. She was in the middle of a shift at the automotive plant where she'd been working since her discharge. Not because she wanted to, but because the transition out of the forces had been harder than anyone prepared her for, and the plant paid steady money and didn't ask too many questions about the gaps in her civilian resume. X. Her phone rang just after noon. It was her mother. Her mother's voice was doing the thing it did when she was trying to hold herself together. Very flat, very even, like she was reading from a script. X. Adaeze, it's about your grandmother. X. She left the plant at her lunch break and didn't go back. X. By the time she reached Miss Viv's house that evening, her grandmother was sitting at the kitchen table with every piece of paper she had ever saved. Tax receipts, utility bills, mortgage statements going back to 1983, a lease agreement from before she owned it outright, spread across the surface in careful piles. Miss Viv was 81 years old and she moved slowly, and her hands shook slightly when she poured tea, but her mind was the sharpest thing in any room she entered. X. Someone signed my name, she said when Adaeze sat down across from her. X. I know, Gran. X. I did not sign anything. X. I know. X. I want to make sure you know that, because I am going to need you to believe it when no one else does. X. Adaeze looked at her grandmother across the stacks of paper. Miss Viv was watching her with the particular stillness of someone who has seen enough of the world to know that most battles are decided before the first word is spoken, decided by who blinks, by who apologizes first, by who believes they have the right to take up space in the room. X. I believe you, Adaeze said. X. Miss Viv nodded once. Then she pushed a stack of documents across the table. Then let's start. X. They called 3 lawyers in the first week. X. The first one said the case had merit but quoted a retainer of $8,000. The second said the same thing and quoted 12. X. The third was kind enough to meet them for free for 30 minutes, at which point she told them, gently but directly, that property fraud cases were complicated, that the statute of limitations clock had already been running for 14 months, and that without substantial documentation proving the signature was forged, the case would be very difficult to win. X. What kind of documentation? Adaeze asked. X. The lawyer listed several things. Original notarized documents, a certified handwriting expert, witnesses who could confirm Miss Viv's whereabouts on the date the transfer was processed, bank records showing no proceeds of sale were ever deposited to Miss Viv's accounts. X. Can we get those things ourselves? X. The lawyer looked at her for a moment. In theory, she said, but it would take time and expertise, and frankly, X. Thank you, Adaeze said. We'll take it from here. X. Her mother, who had come to the meeting, grabbed her arm in the elevator on the way down. Adaeze, we cannot represent ourselves. We don't know how to. X. I was an intelligence analyst, Mum. Adaeze looked at her. For 4 years, I read documents, found inconsistencies, and built cases for people who made decisions based on what I found. I know how to read paperwork. I know how to find things that don't belong. She pressed the lobby button. Gran didn't sign that document, which means someone made a mistake. And the thing about mistakes is, they leave traces. X. She spent the next 6 weeks barely sleeping. X. The dining room table at her apartment became the operations center. She printed everything. She created a timeline, color-coded, taped to the wall. She filed Freedom of Information requests with the City of Windsor for every record associated with the property transfer. She contacted the Ontario Land Registry Office and requested the original submission documents. She cross-referenced dates. X. She found the first problem on a Wednesday night at around 2 a.m. X. The transfer document listed a witness signature, a notary public named R. Fleming, registered in Windsor. Standard procedure. Except when Adaeze pulled the Ontario Notary Public Registry, she found that R. Fleming's registration had lapsed 11 months before the document was filed. The signature was real. The registration was not. A notarization performed by a lapsed notary was, under Ontario law, legally invalid. X. She sat very still at her table for a long time. X. Then she picked up her phone and called her grandmother. X. It was 2:17 in the morning. Miss Viv picked up on the second ring. X. Gran, did I wake you? X. No, said Miss Viv. I was reading. What did you find? X. Here's the thing they don't tell you about courtrooms. They're not designed for you to win. They're designed for the people who already know the language, who already know where to stand and when to speak, and how to phrase a sentence so it lands clean and doesn't give the other side anything to hold on to. The furniture is heavy. The ceilings are high. Everything about the physical space is designed to remind you that you are a visitor, and visitors do not make demands. X. Adaeze knew this. She had walked into spaces that weren't designed for her before. She knew the way a room could try to make you small just by existing the way it did. X. She stood up straight and she held her folder and she waited. X. The opposing counsel was a man named Thomas Hartwell. He had been practicing property law in Windsor for 22 years. He wore a charcoal suit with a pocket square, and he had the relaxed posture of someone who had won so many hearings by lunchtime that the whole thing had stopped feeling like a contest. X. He glanced at Adaeze once when she entered the courtroom and then very deliberately looked away, the way people sometimes look away from things they've already decided don't require attention. X. Miss Viv sat beside her. She had worn her best dress, a deep green with small white buttons at the cuff, and she had her hands folded in her lap, and she was looking at the judge with the same expression she used when she was waiting to see whether a person was going to be worth her time. X. The judge's name was the Honorable Douglas Cartwright. He had heard the preliminary motion submissions. He had read the briefs. He looked over his glasses at Adaeze when she stood to present, and there was something in his expression, not cruel, not dismissive, just a kind of benign skepticism that suggested he had seen this before. Young people, family members, people who believed that love was enough to substitute for expertise. X. You're representing yourself and your grandmother? He asked. X. Yes, Your Honor. X. You understand this is a property fraud claim with significant legal complexity. X. Yes, Your Honor. X. He looked at her for a moment. Somewhere behind her, she heard a quiet sound from the gallery. Not quite a laugh. Almost a laugh. The sound a room makes when it has already decided something. X. Adaeze didn't turn around. She looked at Judge Cartwright and she waited. X. Thomas Hartwell was already leaning back slightly in his chair, with his pen resting between two fingers, patient in the way that cats are patient when they're watching something that cannot escape. X. Very well, said the judge. You may proceed. X. She laid it out methodically. That was her training. Not to perform, not to impress, but to present. To build a structure so clear and so sequential that the conclusion was unavoidable. She had learned this in briefings where the people listening could not afford ambiguity, where a missed connection meant something worse than a lost case. She presented the timeline first. She walked the court through the dates. The date of the alleged transfer. The date Miss Viv had verifiably been in Scarborough. Documented by a boarding pass, a pharmacy receipt timestamped to a drugstore 3 streets from her sister's apartment, and a photograph posted to her sister's Facebook page, with a date stamp showing Miss Viv at a family dinner the same evening the transfer was recorded in Windsor. Thomas Hartwell objected twice. Both objections were overruled. She presented the signature analysis second. She had paid, out of her own pocket, $240 for a 2-page preliminary analysis from a certified forensic document examiner in Toronto. It wasn't a full expert report, she couldn't afford a full expert report, but it was enough. The analysis identified 7 specific inconsistencies between the signature on the transfer document and a sample of Miss Viv's genuine signatures taken from her 2019 mortgage renewal, her 2021 tax filing, and a 2022 letter she had written to the Windsor Star about a rezoning proposal in her neighborhood. 7 inconsistencies, documented, in writing, signed by a professional. Thomas Hartwell objected again. He argued the preliminary analysis was insufficient to meet the evidentiary threshold. Your Honor, Adaeze said, I'm not asking the court to make a final determination based solely on this analysis. I'm asking the court to consider it in combination with the other evidence I'm presenting as part of a pattern. The judge looked at her. Then he looked at Hartwell. Overruled. Continue. She saved the notary for last. Your Honor, I'd like to direct the court's attention to the witness certification on the transfer document. It bears the signature and stamp of a notary public identified as R. Fleming, registration number ON2847F. She placed the document on the bench. She placed beside it a printed record from the Ontario Notary Public Registry. Registration number ON2847F was suspended on March 14, 2022. The transfer document is dated November 9, 2022. 8 months after the suspension, she paused. A notarization performed by a suspended notary public has no legal standing under the Notaries Act of Ontario, which means the transfer document itself is not properly executed, which means... I understand what it means, said the judge. The room was very quiet. Thomas Hartwell was no longer leaning back. He was sitting forward, both hands on the table, looking at the document with an expression that had lost all of its patience. Adaeze stood still. She let the silence be what it was. This is a thing she had learned, not in the forces, but before, from her grandmother, in the kitchen on Carlton Avenue when she was 9 years old and crying because a girl at school had said something that wasn't true about her. Miss Viv had sat across from her and said, "When you have the truth on your side, you don't need to fill the silence. Let the room hear it." So she let the room hear it. Judge Cartwright called a 15-minute recess. In the hallway, Adaeze's mother put both hands on her face and stood very still. Adaeze sat on a wooden bench and ate half a granola bar she found in her blazer pocket and stared at the floor. How are you feeling? Her mother asked. Fine. You don't look fine. I'm fine. She finished the granola bar. I just need him to ask Hartwell one thing. What thing? I need him to ask Hartwell to produce evidence that the notarization was valid. Her mother sat down beside her. And if he can't? He can't, Adaeze said. There is no valid notarization. There is a suspended registration and a stamp that was used illegally. The only question is whether the judge is going to ask him to prove otherwise, or whether he's going to let Hartwell redirect the whole thing. She looked at her hands. Gran always says the truth shows up. I just need it to show up before 3 o'clock, because that's when Hartwell's team is going to try to file an adjournment request. Her mother was quiet for a moment. Then, how do you know that? Because it's what I would do. When they returned to the courtroom, Judge Cartwright looked at Thomas Hartwell. Mr. Hartwell, he said, I'd like you to direct me to documentation confirming the valid standing of the notary at the time of this document's execution. Thomas Hartwell straightened the papers in front of him. He was very controlled. He had been in rooms like this for 22 years. But there was something happening in the set of his shoulders, a tightening, just barely visible, the kind that happens when someone realizes the exit they plan to use is no longer there. X. Your Honor, I would submit that the question of notarial validity is a technical matter that... X. It's a yes or no matter, Mr. Hartwell. Can you produce documentation confirming valid standing? X. A pause. X. Not at this time, Your Honor. X. 4 words. X. Not at this time. X. The room shifted. Adaeze felt it. A change in pressure, like the moment before weather breaks. The bailiff near the door stopped looking at his shoes. Miss Viv, beside her, exhaled very slowly. X. Given the evidence presented, said the judge, I'm finding sufficient grounds to void the transfer document on the basis of improper execution. The property transfer to numbered holding company 2847193, Ontario Inc. is hereby set aside pending a full fraud investigation. He looked at Adaeze over his glasses. The court will also be referring this matter to the Law Society for a review of the circumstances surrounding the filing. X. He set down his pen. X. Miss Obi, he said, this was well presented. X. Outside on the courthouse steps, the November air hit them cold and clean. Adaeze stood with her folder and her borrowed blazer in her grandmother's hand in hers, and for a moment none of them said anything. X. Miss Viv was looking at the street. The marigolds on Carlton Avenue would be long dead by now. November took them every year without exception, but they'd come back in spring. They always came back. X. You knew, Adaeze said. From the beginning you knew we would win. X. No, said Miss Viv. I knew you would find it. There's a difference. She squeezed Adaze's hand once. I raised your mother to believe that the truth could be found if someone looked hard enough. Your mother raised you the same way. I've been watching you look hard enough your whole life. X. Adaze's mother made a sound that wasn't quite a word. X. Adaeze looked at the street. A woman was walking a dog on the other side. A bus went by. The city kept moving the way cities do, indifferent, continuous, not waiting for anyone's moment to finish. X. Gerald Prentice. And yes, there was a Gerald Prentice behind the numbered company, the way there always is a person behind the paperwork, was not in the courtroom that day. He sent lawyers to do what lawyers are sent to do. But the fraud investigation that followed the ruling reached him in January. X. This is the part they don't always put in the story, because stories are supposed to end at the triumph. But Adaze's grandmother asked her, that evening, over tea at the kitchen table with the documents finally put away, what would happen to the man. And Adaeze told her what she knew. X. The Law Society investigation found that the same notary, R. Fleming, suspended, had been used on 4 other property transfers in Windsor and Leamington over an 18-month period. All 4 involved elderly homeowners. 3 involved properties in predominantly black neighborhoods. Gerald Prentice faced charges under the Criminal Code of Canada for fraud over $5,000 and uttering a forged document. His real estate holdings were frozen pending the outcome. X. He has not worn boat shoes since. Whether that's justice or just weather, it's hard to say. X. Miss Viv's front door is still burgundy. X. Adaeze repainted it for her in April, the spring after the ruling. She stood on the front step with a brush and a can of the exact same color. She'd taken a chip of the old paint to the hardware store and had them match it. And she thought about the woman who had sat across from her at the kitchen table the night all of this started and said, I am going to need you to believe me when no one else does. X. She finished the door and stepped back to look at it. X. Behind her, Miss Viv came out with 2 cups of tea and handed one over without asking if she wanted it, because Miss Viv had never once in her life asked a question she already knew the answer to. X. The marigolds were coming up along the walk, small and yellow and stubborn, the way things are when they've decided to come back. X. Adaeze drank her tea. The door was exactly the right color. Some things, she thought, are worth every single hour of getting them right. X. I keep thinking about that granola bar. X. Adaeze, sitting on a wooden bench in a courthouse hallway, eating half a granola bar she found in a borrowed blazer pocket, waiting to find out if the truth she'd spent 6 weeks excavating was going to be enough. That image stays with me more than the verdict does. Because that's where the real story was, not in the courtroom, not at the moment the judge said the words. It was in that hallway, in a young woman who had every reason to walk away choosing, very quietly, not to. X. What Gerald Prentice counted on was ordinary. He counted on the fact that most people, when they hit the first wall, turn around. He counted on the cost of lawyers, the weight of legal language, the sheer exhaustion of fighting a system that wasn't built to make things easy for people like Vivienne. He counted on the idea that an 81-year-old woman in a wheelchair and her 24-year-old granddaughter would look at the size of what he'd done and decide it was too much. He was wrong about all of it, and that wrongness cost him everything. I think about cause and effect a lot, not in any mystical sense, just the plain observable fact that what people do tends to return to them in kind. Prentice built his scheme on the assumption that vulnerability was permanent, that people without resources stayed without resources, that a forged signature and a suspended notary and a numbered company were enough to make something permanent. But he didn't account for what happens when someone who has been trained to find inconsistencies in high-stakes documents decides that finding the inconsistency is the most important thing she's ever done. He didn't account for a dining room table covered in color-coded timelines. He didn't account for a phone call at 2:17 in the morning and a grandmother who picked up on the second ring. What Adaeze had wasn't magic. It was three things, and I think they matter. She had integrity. She didn't give up on her grandmother because giving up would have been easier. She had the intelligence to know that the truth was findable if she looked hard enough, and the discipline to look. And she had the kind of quiet stubbornness that doesn't announce itself, doesn't perform, just keeps going. The kind that sits in a courthouse hallway eating a granola bar and says, "One more thing to try." Those three things together are what Miss Viv planted in that family over 41 years in a house on Carlton Avenue. You don't get a granddaughter who fights like that by accident. You get her by showing her, every day, what it looks like to hold your ground with dignity, to tell the truth even when the room has already decided not to believe you, to let the silence do the work when you know what's in it. Gerald Prentice is facing fraud charges now. The door on Carlton Avenue is still burgundy. The marigolds came back. Some things are worth every single hour of getting them right.